Welcome to Module 3. In this module, we're going to discuss the civil liability that you can be held accountable for by over-serving alcoholic beverages to your customers or serving alcoholic beverages to minors. The majority of states in the U.S. have dram shop laws, also known as third-party alcohol liability lawsuits. The Dram Shop Act/third-party alcohol liability lawsuit derives from common law that initiated in England long before the Pilgrims landed at Plymouth Rock. A third-party lawsuit is a lawsuit in which the injured person, who you did not serve, sues you for injuries he claims to have received because you overserved the defendant or served alcohol to a minor who causes an accident, property damage, personal damages, etc. The monetary amount awarded to the victims can be in the millions of dollars. Here's a quick trip to law school. A tortfeasor is a civil wrong. Negligence is an example of a tort. You can be negligent if your conduct unreasonably creates a foreseeable risk to a protected interest. Wisconsin has a limited Dram Shop Act law, which we will cover in just a bit. Even though Wisconsin's dram shop laws are limited, keep in mind that you can get sued for anything. The question is, will the person suing you win? The best way to avert being sued is not to overserve and don't serve minors. In essence, follow all liquor laws, which are in place for public safety. What are the dram shop laws for Wisconsin? Wisconsin Statute Section 125.035 states that a person is immune from civil liability arising out of the act of procuring alcohol beverages for or selling, dispensing, or giving away alcohol beverages to another person. This statute, dram shop situations, in which alcohol is sold by a licensed vendor, and social host situation when alcohol is served to guests at a private event. But Wisconsin does recognize some exceptions to the statute. There are situations in which a vendor or host may be held liable for providing alcohol to someone who becomes intoxicated and ends up harming a third party, such as when alcohol is served by force or by deception, such as claiming the beverage is alcohol-free, and when alcohol is provided to a minor and is a substantial factor in the resulting injury. Or the intoxicated person crossed state lines into a state with different dram shop laws, such as Illinois. Then the state the accident took place in, that state's dram shop laws could be enforced, which opens up a whole new set of damages that can be sought, such as lost time from work, medical costs, even if they have insurance, loss of life, loss of quality of life, loss of a child, loss of a parent, etc. Here's an example of Wisconsin's dram shop rules at work. Mike goes to Joe's Bar and Grill to have a couple of drinks. After consuming several drinks, Mike goes downstairs to the bar's game room to play pinball. As Mike is going down the stairs, he stumbles into Mary, who is coming up the stairs. Mike and Mary fall down the stairs, and both are injured. As long as Mike is 21 years of age or older, Mary cannot seek damages from Joe's Bar and Grill for serving the alcohol that caused Mike to stumble into her and knock her down the stairs. However, Mary can seek damages directly from Mike for causing her injuries due to negligence, and if the staircase had any issues, such as if it had no railings or a step was broken, both Mike and Mary might be able to bring a premises liability claim against Joe's Bar and Grill. Social host in Wisconsin. Like alcohol vendors, social hosts, persons hosting an event, generally can't be held liable if they provide alcohol to a guest who then injures someone else. However, social hosts may face criminal penalties if they provide alcohol to a minor under age 21 who injured someone else in an alcohol-related accident. Social hosts who allow minors to drink on their property may also be ticketed and fined in many Wisconsin cities and towns that have social host ordinances. Remember, you can get sued for anything. Question is, who will win? Here's a setting in which a social host liability might apply. Shauna hosts a party at her house, and her neighbor Lindsay, who is a 16-year-old minor, comes to the party and drinks several beers. Shauna sees Lindsay drinking alcohol, but doesn't stop her from consuming the beer. Lindsay leaves the party at Shauna's and drives to a friend's house when she has a car accident injuring Brian and Christian, two guys headed to meet their wives for dinner. Brian and Christian can seek damages from Lindsay for causing their injuries. Each of them can also bring a civil claim for damages against Shauna if they can prove that Lindsay's intoxication was a substantial factor in the accident that injured them. In addition, Shauna may also face criminal penalties for providing the alcohol to Lindsay, who is under the legal age to consume alcoholic beverages. The penalties could be a felony, which can be punishable by up to $10,000 in fines and 6 years in jail, or $25,000 in fines and 10 years in jail. Wisconsin law prohibits an adult from knowingly permitting or failing to take actions to prevent the illegal consumption of alcohol beverages by an underage person on any property that is owned and occupied by the adult or occupied and under the control of the adult. The prohibition applies to lodging establishments defined as a bed and breakfast establishment, hotel, tourist rooming house, or campground only if the adult has furnished payment or security for the lodging. Damages in Wisconsin alcohol-related injury cases. A person who is injured by an intoxicated individual can typically file a personal injury claim against the intoxicated persons who caused the injuries. In alcohol-related injury cases, common categories of damages include compensation for medical treatment. A personal injury damages award almost always include the cost of medical care associated with the accident. Reimbursement for treatment. The injured person has already received in compensation for the estimated cost of medical care they will need in the future because of the accident. Income. The person injured may be entitled to compensate for the accident's impact on their salary and wages, not just income they have already lost, but also the money they would have been able to make in the future were it not for the accident. Damages awards based on future income is characterized as compensation for an accident's victim loss of earning capacity. Property loss. If any vehicles, clothing, or other items were damaged as a result of the accident, they will likely be entitled to reimbursement for repairs or compensation for the fair market value of the property that was lost. Pain and suffering. They might be entitled to get compensation for pain and suffering, discomfort they suffered during the accident, and its immediate aftermath. Also, for any ongoing pain that can be attributed to the accident. Emotional distress. Usually linked to more serious accidents, emotional distress damages are meant to compensate a personal injury plaintiff for the psychological impact of an injury, including fear, anxiety, and sleep loss. Some states consider emotional distress as part of any pain and suffering damage that is awarded to a personal injury plaintiff. Loss of enjoyment. When injuries caused by an accident keep the injured person from enjoying day-to-day pursuits like hobbies, exercise, and other recreational activities, they might be entitled to receive loss of enjoyment damages. The statute of limitations for lawsuit to be filed is 3 years from the date of the injury.